Good evening, everybody. You are watching Moving Families Forward with Williams Law Group. I am Allison Williams, the founder and CEO of Williams Law Group. And I have a special guest for us tonight on the show, Scott Goldstein, who is a bankruptcy attorney who I'm going to introduce shortly. So, for those of you that are just tuning in, thank you so much for coming at the top of the hour. We like to say a saying here at Williams Law Group that sharing is caring. So please do share the live so that friends, family members, anyone that you know in your network can get the great benefit that we're going to share with you tonight when we talk about tonight's topic of bankruptcy. So, for those of you that are new to the show, just a little heads up about why we're doing this, what the show's about. We are a family law firm here at Williams Law Group, and we help families in a variety of contexts dealing with issues that impact their family. In particular, divorce, custody, child support, domestic violence, um, modification and enforcement of applications, as well as child abuse and neglect. And in the context of helping families, it really is impossible for the matrimonial attorney to be truly effective unless we have a great toolbox of resources that we can turn to help our clients. So we're always looking for those right experts, those people that are our trusted go-tos that can give us advice, guidance, resources for our clients to help them through the process. And over the years, we've encountered so many different kinds of professionals, people that work in financial services and mental health services, other attorneys in other practice areas that really don't just give our clients legal representation, but give our clients hope and help them rebuild their lives through this process of divorce. So, with that, we created the show so we can share with you some of the great resources that help our clients, and hopefully they give you some value as well. So, I'm going to turn the floor over now after giving an introduction to my friend and colleague, Scott Goldstein. So, Scott is founder and principal attorney at the law offices of Scott Goldstein. He's admitted to practice in the states of New Jersey and New York, as well as the district court and bankruptcy courts of the District of New Jersey and the southern and eastern districts of New York, which means he can go a lot of different places to do what he does. He has been quite the accomplished attorney. He's been in a lot of very prestigious firms doing what he does. But after having quite a bit of experience collected in commercial litigation and fidelity and surety law, as well as in bankruptcy, he hung his shingle back in 2010, and since then has been helping a lot of well-intentioned, good, hardworking people with this issue that we're going to talk about tonight. He is a proud member of the National Association of Consumer Bankruptcy Attorneys. He's also a member of the American Bar Association, the American Inns of Court, as well as the Bankruptcy Inns of Court. He has been a lecturer on Lawline, which is a continuing legal education resource for attorneys. So he's an expert in his field. We're not supposed to use that word in the legal profession.
Nope.
So I won't use the E word. I will just say he's a damn good lawyer. And in the damn good lawyer field, when you get to be a damn good lawyer, you get to teach your brethren how to do what you do. So he does that for Lawline, which gives resources to attorneys to keep themselves up on the law. And he also assists indigent debtors as a volunteer attorney for the legal services of Northwest Jersey. So the one last thing I want to say about Scott before I turn the floor over to let him say a little bit about himself beyond what I'm sharing is that much to my heart's content, he is an active supporter of Children's Specialized Hospital and St. Barnabas Hospital, their NICU. So with no further ado, I will turn the floor over to our guest for tonight, Scott Goldstein. Scott, thank you and welcome to the show.
Thank you, Allison. Appreciate it. Hopefully everyone can hear me. So just to follow up a little bit, my firm does probably 85% of our time is spent on bankruptcy matters, both sometimes for creditors too, but mostly for consumer and consumer small businesses, that kind of people. We've had everything from a legal services referral where the person had literally nothing to his name but a 94 probe, all the way up to former millionaires. So it really is the full gamut of debt issues. And sometimes we do assist creditors in asserting their claims because if somebody owes you money and they go into bankruptcy, the last thing you want to do is go it alone because you could end up getting yourself some serious trouble with overzealous attorneys like myself, who will come back very quickly if you mess up. Let's put it that way. We've probably filed in the last 10 years, I'm guessing about 1,000, a little more cases since we started, which for a solo shop is pretty good, I think.
Wow.
So.
Definitely, definitely. So, Scott, like I said earlier, this issue of bankruptcy is one that touches a lot of families that we help in the course of divorce, and obviously people that just consult us about different family law disputes. But let's start with a working definition. Tell us, what is bankruptcy as a discipline?
Bankruptcy is the legal proceeding whereby an individual, generally, or a business, can obtain a discharge of their debts and relief from their debts, either through a straight whitewash, essentially, or through reorganization. Individuals can file, businesses can file. The main difference is that individuals can receive a discharge. They will be, at the end of whatever it is you're going to do, whatever debts are allowed to be gotten rid of are gone. They cannot be collected against. You have a court order and injunction prohibiting any creditor from seeking to collect against it. Businesses can reorganize or liquidate, whereby they close out, and they get to do it in an organized fashion, but they don't get a discharge.
Well, then what would be the purpose of a bankruptcy for a business if not to discharge the debt? If all I'm going to do is just restructure my debt, I can just live with it unstructured, couldn't I?
The problem is when you are a business. So let's start with the two sides. There's two sides: liquidation and reorganization. Liquidation, the goal for a business liquidation, which is not my preferred method of dealing with it, but I'll do it if it's an appropriate situation, is for the business owner to close the business down in an organized manner, hand whatever there is over to a Chapter 7 trustee or a liquidating 11 trustee, give it to somebody else to deal with, and walk away. Oftentimes, the individual will be filing a personal bankruptcy as well, but it helps clean things up easily. In terms of restructuring, that's usually done in Chapter 11 and this is not as much what I do. This is more high-level, big white shoe firms. But for the small firm, it allows them to restructure a lease, restructure secured debt, and keep a business that is drowning afloat, and allows them to get some sort of functionality again and be able to re-maximize the value of the business as a going concern rather than close the doors and lose everything.
Great. So thank you for that explanation, Scott. I just want to let you know that my friend Judy Ann Chung has dropped in. Judy Ann's a leadership coach. So Judy Ann, thank you for joining us tonight. And Scott, you somewhat answered my next question, but I really want to just ask it just to make sure all our bases are covered. This idea of, you reference chapters, and I hear people talk about the different chapters of bankruptcy all the time, and most of us that don't do this don't know what the heck that means.
Okay, it's exactly what it sounds like. Like every law, you've got sections, chapters, subsections, and all that other fun stuff that drafters like to do to make our lives difficult. So the Bankruptcy Code has, I think, 15 chapters. There's one or two that are not used. I think there is no Chapter 6. There is no Chapter 8. I don't know why. Ask Congress. But there are 1 through 5 are chapters 1, 3, and 5 are actually, you know what? I'll take it back. Except for Chapter 12, there are no even chapters used in the Bankruptcy Code at this point, I think.
Wow.
I don't know why. Again, I don't know why they did it that way. Maybe they're saving it for something new and interesting someday that they're going to spring on us. We'll see. But there are the first 3 chapters in the Bankruptcy Code are operational chapters. They give definitions. They tell you what you're supposed to do. They give certain injunctions. Chapter 7, 11, 12, and 13, and 15 and 9 are the chapters that describe how bankruptcy works for each different kind of group. So for individuals, Chapter 7 is a liquidation case. It describes who can be in it, how it works, the duties of the trustee and the debtor. Chapter 11, and same thing, 11 describes it for businesses and large-scale reorganizations. Chapter 13 describes an individual's reorganizational case. Chapter 15 describes a cross-border case. Chapter 12 describes how to and sets the rules for reorganizing a family farmer or fisherman. So it's just literally the chapters of the book that you have to go through.
Gotcha. So as you were giving us that definition, one of my associates, Arish Saeed, did hop in to say hello to us. So Arish, thank you for hopping in. and saying hello. So, you know,
Shouldn't
it's
ours be working?
well, every once in a while, we turn off the electrified fence here at this law firm and we let people scurry out and escape at the late hour. But in all seriousness, the idea of the restructuring of the different structures of the code, for most people, they don't really need to know that. They really need to
Yeah,
know. They walk into your office, and I imagine they say,
right.
I'm scared. I've got a lot of debt. I have to decide, how to
Yeah.
do this, when to do this, what to
What are you
do.
going to do?
So
Yeah.
why don't we start with this? What first of all, is there a right time for somebody who's contemplating to actually go about the process of filing?
I would say the right time is when you start to realize that you're not going to be able to make certain payments that you need to make. That maybe you're going to start falling behind in your credit card debt. But the problem is that right time for different people is it's on kind of on a sliding scale. The one time that I say is not the right time and you're kind of late is when you've already burned through all your 401k, all your retirement savings, and you've burned yourself, and now you're down to no savings whatsoever because there's a lot of stuff you can protect in bankruptcy. So the time to file is when you start seeing disaster looming financially. And it is not when you've burned through everything trying to avoid it. You're far better off coming in earlier in the process when you still have something to save.
Hmm. Well, I mean, that's kind of that's an interesting
It's
that's
hard.
it's an interesting conundrum because I know a lot of people that bankruptcy still has a stigma associated
It
with it,
does.
especially for people that we had a lot of people that really never encountered financial difficulty until
Mm-hmm.
either someone lost a job, someone fell very ill, and thus mounting medical bills just became overwhelming or oppressive, or someone went through what we deal with, a divorce. And so if you have a scorched
Right.
earth approach by one of the spouses, and now you're
Yeah.
spending all of your money defending yourself, or God forbid, if somebody falls into a mental incapacity as a result of the
Mm.
stressors of divorce, you can easily spend 10, 15, 20, 100, if $200,000, if not up to $1 million on legal fees. And
Yes,
so
you can.
when people do that, when they do that to each other, or when they have it done to them by their spouse, and they have a mounting debt, not just to their divorce attorney, but to all the people involved in the process, they oftentimes are trying to avoid bankruptcy by, spending their savings and, tapping the
Yeah.
401k and all that. So, how do you counsel somebody who's kind of already gone down that line? Do you say, all right, well, you've already hurt your credit and
Mm.
you've already spent your
The
money, so don't bother?
No, at that point, it's time to stop the bleed. I kind of use the for a lot of my clients, especially when they start asking about with your credit and things like that. I kind of liken it to having an infected wound at that point. The bankruptcy is cleaning it out and cauterizing the wound and stopping the bleed, and then the financial healing can start. Because I'm going to assume, let's say for instance, someone has gone through a really nasty divorce. Everything's divvied up. It's all finally done, except for the post judgment motions. And now they're looking at their financial life. They're now one income where once there were two. Um, they're now looking at, well, I have all this debt that I racked up because I ran up my credit cards to pay my lawyer, to pay for all these other things while I was fighting this divorce. Now what do I do? So at that point, it is time to look at the finances and say, well, can you pay your bills and continue along? Can you pay your credit card, all this debt, and maintain a basic standard of living? If the answer is no, then it's probably a good time to look at filing.
Mm.
And to take it a step further, at that point, you also need to look at the real estate aspect of it in many cases, because now maybe you've got somebody who they could afford that, they can afford their house if they're just making their mortgage payment, but maybe they've fallen behind because they were too busy paying divorce fees or other things that came up during the course of a divorce, as we're using that example, and now they've got to fix the problem. So that's a good time to file as well, because bankruptcy is not just erasing debt; it's fixing financial problems and curing a lot of times arrears in things that you need to keep, like houses, cars, things like that.
Wow. Okay. So that absolutely gives guidance for people that are kind of at that fringe of, I've already
Mm-hmm.
spent my money, but I don't really want to pursue bankruptcy and I don't know. So thank you for giving us that answer. And I see more people are coming in. They're not responding, but I can see you're out there. So if you are joining us, please do share the live. Sharing is caring. Please let your friends, colleagues know about what we are talking about tonight, which is the topic of bankruptcy. And for those of you that are new to the show, you are watching Moving Families Forward with Williams Law Group. I am Allison Williams, the founder and owner of Williams Law Group. And I have tonight with us our guest, Scott Goldstein, who is the owner and founder of the law offices of Scott Goldstein, which deals with a series of issues, but what he's probably one of the most well-known attorneys for is the area of bankruptcy. So I see my friend Dr. Carla Cook has come, and she was nice enough to note that she did share the live, and also attorney Robin Scher. Robin, thank you also for joining us tonight. So Scott, I want to turn now to this issue of debt. You mentioned debt before, and kind of starting anew and getting rid of your debt. So is there any situation where someone would actually still have to pay debt after they go through a bankruptcy?
Yes, obviously. So some of the most basic debts that survive would be first, mortgages. If you want to keep your house, you're gonna have to keep paying for it. Cars.
You don't get a free house in your bankruptcy? I mean, isn't that
no? Unfortunately, no. In Ray Washington was overturned. There was one case. Yeah, I have a lot of clients who are very surprised when I tell them, no, you're gonna have to keep paying your mortgage if you'd like that house. We may be able to restructure the mortgage through a loan modification, but basic rule: if you wish to keep your house, you need to pay for it. If you have alimony or child support arrears, those must be paid and continue to be paid. So if you have the arrears, in Chapter 7, those arrears will survive the case, and you will have to continue paying them. In Chapter 13, the reorganization, you must cure your arrears through your plan. It is one of those things that must be fixed when you're doing it. Let's see. Criminal fines and penalties. So if you have restitution payments because you did something you shouldn't have, that must be paid. But your basic debts that people most often deal with, credit cards, medical bills, family loans. What I'm seeing more and more of are these online personal loans, Prosper, Lending Club, things like that. Those are gone.
Okay.
So judgment liens, those go away.
I just want to interject here and say a quick hello to my new partner, Trish Delinsky. Trish, thank you for showing up and watching the live tonight. And so also, Scott, I want to circle back to something that you were saying as you were kind of going through the debts that are included, not included. You mentioned alimony and child support arrears.
Yes.
So you said that is one debt that has to be cured. But one question I had was whether or not the interest that would have accrued on a child support and alimony arrearage, whether or not that can be discharged, because that is not the actual payment. That's the interest that accrues on the payment as a result of the judgment being entered for the child support as of the date of entry.
Normally, we don't deal. Normally, that interest is going to be discharged. From what I can tell, it's never come up really. It's usually whatever the balance is at the time of so if you're in Chapter 7, whatever it is. So it will not be discharged. So that's just going to carry straight through. You file your Chapter 7, you receive your discharge, you still have a whopping child support arrearage due. When you file your Chapter 13 case, the holder of the claim, so the person who's supposed to be receiving the arrears, needs to file their statement of what they're owed, and that will usually include the interest, and that will get paid through the plan.
Okay, that makes a lot of sense. And so I interrupted you earlier. I don't know if you remember where you left off.
No clue.
Okay, great. So with
Take
that,
it away. You asked me a question.
I love it. That's what happens. I wish that happened with judges. I interrupt, they just stop their thinking, and we kind of start over again. But Robin does note that she references student loans, which is a great topic that I'm sure a lot of people have questions about. So what happens with student loans when you go through any form of bankruptcy?
Student loans survive the bankruptcy. The bankruptcy code has a continuously tightening over the years since it was first enacted. Bankruptcy laws in this country have continuously restricted the ability of debtors to discharge student loans. So right now, the basic rule is if you have a qualifying student loan, a federal, any of the federal loans, Stafford, Pell, those absolutely go through completely. The other kinds of loans you have are these private loans, which are the real obnoxious ones. Those will generally survive as long as the loan is a qualifying education loan and it's made for attendance at a qualified higher education institution, which is any one of the many Title, I want to say Title IV, but I'm probably wrong. Whatever the Higher Education Act lists and the Department of Ed lists as a qualifying educational institution, those are the institutions where those loans will not be discharged. It is very hard. The way the code says is you can only get rid of them if the debtor will be forced, if they have to pay this loan, to have an undue hardship. And the definition of
would say paying back loans where you're paying 7 or 8, 10 times what you borrowed is a hardship.
Unfortunately, the way that the judges look at it there's this horrible case called Brunner out of the Second Circuit, which is the test, and you need to show a good faith attempt to repay and basically absolute hopelessness, that you will never ever pay this off, that you will never be able to have any sort of a life. I kind of refer to it as an eye blink test. If you can get a job blinking your eye, you're probably not going to be able to discharge your student loans. That's exaggerating it a bit, but courts have not much. Bankruptcy courts are very loath to give a discharge of student loans. I've been able to do it once because it wasn't I had to file an adversary proceeding to do it, and it was for a non-qualified institution. So a guy took out a loan to go to school at some trade school that wasn't approved by the by the Department of Ed. That loan got discharged.
Wow.
But most, no.
Scott, you're going to get yourself a lot of business by telling people you were able to get a student loan discharged.
The day that Congress actually gets rid of Section 523A8, which is the one that says no discharges for student loans, the question for most bankruptcy attorneys of our student loans is, do I file my own case or sit back and rake in the money when everyone comes to me?
Well, maybe you file your own case first and then you sit back and rake in the money, because I think the two are probably going to go hand in hand. So we actually have some comments coming in. I just want to note that your friend, Sean Kelly,
hi, Sean.
Thank you for inviting him to the live. So, Sean, thank you for showing up to watch and support. We also have a comment by Rona Zysik.
Yes.
I hope I am somewhere near close on that. Maybe kind of, sort of, maybe not. So, Rona, I apologize if I butchered your last name. But Rona's comment is that if somebody lives above their needs and files bankruptcy, will they be penalized for taking advantage of the system? So, Rona, that is a very loaded question, in that a lot of people, and I'm certainly not going to criticize you for having this view, but a lot of people do feel that there are people that just kind of live high on the hog and go out and file for bankruptcy. And, many people have very strong views about that. So without passing any judgment on the question, I would like you to just kind of ask the question about, is there a query about the righteousness of the cause of the person that filed and the reason why they got to that degree of debt that they needed to file for bankruptcy?
Okay, so we don't judge anyone who comes in our doors as to were they spending too much money, things like that. What happens is people build a house of cards financially. Many people do. Some people are really good at living within their income stream. But there are some who they get the credit cards and they use them to supplement their lifestyle to the level they want it to be. Mm-hmm. Most bankruptcy trustees, when interviewing a debtor, because every debtor is interviewed, will say, how did you end up here? I have had one client who said point blank to the trustee, I used my credit cards way too much. I spent way too much money. I knew I couldn't afford it, but I just did it. And now here I am. And the trustee looked at him and said, thank you for your refreshing honesty. I'm going to close the meeting and sent him on his way. There is no penalty for filing a bankruptcy if you have been living above your means, especially in Chapter 7, where everything is now collapsed and the money isn't there anymore to support the credit card payments. I have had clients come in many times where they spent whatever it is for whatever reason, and then the bills came in and they went, oh. And then they came to me because they now realized that perhaps they overindulged. and had been overindulging for years. But I would say the people who are living really high on the hog, racking up credit card bills, that view is not accurate for most people, especially in the current economy.
Yeah. So,
but you do have frequent flyers. Sometimes you will do that.
Yeah.
And we watch for them whenever someone comes in. We do. The first thing I will do when a client comes in is I will check the online filings and see see if they have filed before, because there are penalties for multiple filings in a short period of time.
Oh. Well, when you say a short period of time, this may just be kind of my own false assumptions, but at one point in time, people were told bankruptcy doesn't get discharged for several years. I think it's 7 years, and if you're going to have to wait that long, are you even going to be able to secure more debt unless it's going to be very, very high interest debt during that time period before it's discharged?
No. So a bankruptcy discharge, I think I think you're talking about credit reporting more than a discharge. So a Chapter 7 discharge takes about 120 days to 160 days after filing. You file your case, your creditor meetings 30 days later. 60 days after that is the deadline for proofs of claim or objections to discharge. And then as long as you do one little minor step, taking a certain online course you have to take, and that gets filed with the court, you're done. You receive your discharge. You're out of bankruptcy. Chapter 13 can be 3 to 5 years. Chapter 11 can be, I've had plans for 30 years that I've set up in Chapter 11. But once that's done, then the credit repair begins slowly. I have had clients able to purchase houses 2 to 3 years after filing a Chapter 7 case and getting a discharge, as long as they're careful.
Wow.
I've had former Chapter 13 debtors buy new houses and things like that. I've had clients buy houses within Chapter 13. It's restructuring. So there are time frames, though, within which you may not file again and receive a discharge. So to start off with the penalties, when you first file your case, you have an unlimited protection from your creditors. If you have a case dismissed and file again within a 12-month period, you only get 30 days unless the court grants you additional. And if you have 2 cases within a rolling 12-month period that get thrown out and you have to start again, then you have no protections from your creditors, and you have to impose those protections. If you receive a Chapter 7 discharge, you may not receive another Chapter 7 discharge for 8 years. So I always, when people do come in, I look at how much they owe, and I will tell clients who have not that much debt. Usually I will make exceptions for people with very low income, but usually I'll say under $8,000, $9,000 is not worth it, because based on how much they're going to be paying my fees and how much they owe, it's not worth it to burn that silver bullet quite yet. If you filed for Chapter 7, you may receive a discharge in Chapter 13 after 4 years. I believe it's 6 years between 13s, but I'd have to look at the code again. But there are time frames within which you may not receive a discharge if you filed previously. So it is always something very difficult to tell someone that, well, we can kind of sort of fix it, but you filed too recently, so we have to take a different track. But there are times when it is necessary to file a non-discharging bankruptcy case in order to fix things.
Yeah, definitely. So, Scott, I just want to let you know that Robin Shear wanted an area of clarification. She says
Sure.
she needs to be clear on this. Did you say that interest on child support arrears is dischargeable?
No, I do not believe it is dischargeable. It follows dischargeability of interest follows the dischargeability of the underlying debt.
Okay.
So, and anything arises. So the code says, a debt owed to a spouse or child or former spouse or child of the debtor in the nature of support, and that interest would be in the nature of support because it follows from a child support order.
Right. Thank you, Robin, for asking for that clarification. And I appreciate you giving us that information, Scott. Part of the reason why I asked about it was that in New Jersey, child support becomes a judgment by operation of law the date that it becomes due. So if somebody comes into our office and says the child support probation office has been chasing me for the last 6 months, and now they're threatening to throw me in jail, and my ex just filed a motion asking to reduce my child support to judgment as of date A, I could have interest attached. And my answer to them is always, you already have interest attached. Interest began the day that the judge, the amount was due and it wasn't paid.
Yes.
And so the calculation of that becomes very sophisticated, and many
Yes.
times, because the probation department, which is our collection agency, they are established across the country.
Hmm.
Because it has difficulty in calculating that interest, we often have problems with that. So I know that some people, their amount of child support and the interest just grows and grows and grows, much
Right.
larger than the actual amount of child support due, because the interest has just compounded and
Hmm.
collected over a period of time. So
Yes.
that was the reason why that came up.
Okay.
So let's talk about what bankruptcy does not discharge, because you kind of
All
you
right.
touched on it
Right.
before.
So
There's more.
yeah. So there's two sections for individuals. We'll really just limit ourselves to individuals that say what cannot be discharged. Basic rules: alimony and child support, student loans absent a showing of undue hardship, taxes within certain limitations. The general rule is, and this is very general, timely filed taxes that were due more than 3 years ago and assessed, that were due less than 3 years ago and assessed less than 240 days ago. Those are not dischargeable. Anything involving fraud, theft, defalcation in a fiduciary duty, embezzlement, misrepresentation, anything basically being a bad person.
Defalcation. Now there's a word for you.
That is a quote right off the statute.
Well, let's say that there are some of us that have not read the statute and don't know the
good example of defalcation and fiduciary duty. You're holding somebody's security deposit and you run off with it. That's not going away. You are holding money in trust for your disabled child and you steal from their special needs trust. Things like that.
What an asshole.
Yeah, but you get the idea.
Yeah,
and yes, there are people out there who will do these things. If you have a judgment of fraud against you, so somebody sues you in court and finds that you incurred that judgment because of misrepresentations or actual fraud. Interestingly enough, anything under the Consumer Fraud Act, it might actually not qualify for fraud under the bankruptcy rules, because consumer fraud is
fraud light.
Basically it's fraud light. It's, I said it was red, but it's actually more burgundy. That could be consumer fraud if someone's really feeling aggressive.
Oh, wow.
That's strict. It really is kind of fraud light because it doesn't require intent. You need to have the intent in bankruptcy. Willful or malicious debt owed by reason of willful and malicious injury to another person, that is really reserved for intentional torts. So, aiming the car for someone when you run them over, things like that.
Okay. Well, if I ran you over and I didn't aim the car, then
then that's negligence. Maybe. Then you're fine. Yeah, negligence is fine. Knowing and willful injury willful and malicious injury, criminal restitution, as I think I mentioned before. There's some other more obscure things. Debts owed to ERISA plans. So if you have a 401k loan, you're gonna have to pay that back. Or if you have a pension loan, you're gonna have to pay that back no matter what. Debts owed to maintain a 401k plan. So if you're a business owner and you need to maintain that 401k, debts owed. There's something in there about debts owed to maintain balances of an FDIC insured institution. Not quite sure. I've never come up against that in one of my cases, but it's in there somewhere. Wow. So there's a laundry list. That's for Chapter 7. That's a huge laundry list of stuff. But most people don't fall into these categories. There's a lot of them, but they're very narrow. Chapter 13 is more restricted. So one very important thing for your clients to know is when you're dealing with divorce debt, okay? Alimony and child support across the board, non-dischargeable, period, dot. You must cure it within a Chapter 13 if you wish to receive a discharge. Debts owed, however, by reason of anything else in the divorce decree are different. And I'm just litigating this right now. If you owe something in the way of equitable distribution, a debt assigned to you, let's say, the judge says, okay, you pay the Amex and you pay the Citi card, right?
Mm-hmm.
Things like that. Unless the judge says in his order, if you don't do it, it's going to be considered in the nature of support, it'll be considered ordinarily equitable distribution of debt, right? That is dischargeable in Chapter 13. It is not dischargeable in Chapter 7. So Chapter 13 has a much narrower scope of non-dischargeable debts. We call it, when we recall receiving a Chapter 13 discharge, a super discharge, because there's more stuff that gets included and protected. So another fun fact, you cannot discharge traffic tickets or the penalties from Easy Pass when you don't pay the toll.
Okay.
In Chapter 7. You can discharge them in Chapter 13.
Wow. So a lot of different options there. And I just want to acknowledge my good friend, Christine Mattis. Christine was on our show a while ago. She's a special needs attorney from Tom's River. So I know that you two have some overlap in an area that you both practice in. And we have some more faces coming in. So I just want to remind everybody that if you're just showing up, sharing is caring. Please do share the live so that your friends and colleagues and people in your network can learn about our topic for the night, which is bankruptcy. And for those people that are just tuning in, you are watching Moving Families Forward with Williams Law Group. I am Allison Williams, the host and owner and founder of Williams Law Group. And we have our special guest tonight, Scott Goldstein, who is an attorney that focuses on many different areas, but is best known for his expertise as a bankruptcy lawyer. So a lot of things that can't be discharged, but some things that can be discharged. I think it's an amazing topic that you raised earlier, this idea of debts distributed in divorce. Because one of the things that we always talk about with our clients is the idea of doing accord and satisfaction if you're going to be trying to eliminate debt or limit debt to get yourself the greatest start forward after divorce. So I don't know if that's something that, it is a taxable event if you do an accord and satisfaction. So for those of you that don't know that, that's when you go to your credit card company and say, hey, I owe you $1,000, but I've got 400 and I'm getting divorced and there's no more money. So take 400 and relieve me of the remaining 600. When you do that, that $600 savings that you have is considered taxable income, and you have to report that. So I don't know if that would be treated in any certain way in bankruptcy, if that's something that could help or hurt you.
Well, I tend not to. When you do those accords and satisfaction, we just kind of lump it all in debt settlement. Debt settlement has a kind of an ugly connotation in bankruptcy attorney world, because usually when people talk about debt settlement, we're talking about those guys who are on the radio. We'll do whatever for you for 50 cents on the dollar, and then your clients get sued into oblivion because they're not settling anything out.
Yeah.
Debt settlement is a very useful tool, and we always discuss with our clients the options to, in and out of bankruptcy. And it is a reasonable, if you're not going to file, it's a reasonable thing to do. And if you're already really pretty much insolvent, you don't have a lot of assets, there is a provision in the Internal Revenue Code to not get nailed for that canceled debt. So I think it's a Form 8820 or something like that. You can file. When you file your taxes, show that you really are insolvent, your debts exceed your assets, and therefore they will not nail you for that debt forgiveness. That is, if you can do that, great. If you can avoid bankruptcy, I'm shooting myself in the foot a little bit, but it's better to resolve things if you can. Most people who've come into my office, they don't have that money to throw at the problem, because debt, accord and satisfaction only works if you have chunks of cash to throw at the issue.
Right.
If you're strapped, which most of my clients are, which usually comes to the interesting question of how are you actually getting paid? But most of my clients,
attorney-client privilege, nobody can find that out.
No one can find that out. Generally, they find a way. But for the most part, clients, they're overwhelmed. If it's 3 or 4, maybe even like 5 credit cards, and the balances aren't too high, you can settle them out, and you can do it in a reasonable manner, and you can do it before you get sued, before there's too much damage to your overall financial life. The problem is that when you've got tens and tens of thousands of dollars in credit card debt, many credit card companies won't negotiate it down, or won't negotiate it to a level that you can afford. And while you're sitting there and now you're going to start defaulting, your interest rates spike to the default rate, which is as close to the usury rate as you can get. So I think almost 30%. They start spiking the interest rate. They reduce the limits. So once you may have had room at one point, you won't have room anymore. And that's when the house of cards that I mentioned earlier collapses.
Yeah. Well, it's interesting you mentioned the house of cards, because there are a lot of people that don't necessarily rack up credit card debt because they're just irresponsible
Hmm.
and indifferent. I think a lot of people just don't understand fundamentally the nature of money, how money works, how credit
Hmm.
works, how interest works. In fact, one of my good friends, Judy Ann Chung, used to work in the financial services industry. So I know that Judy Ann has a particularly robust knowledge of it. But a lot of people come in and I think they just kind of rob Peter to pay Paul and
Hmm.
expect that, okay, I'll get my next bonus, and then, okay, crap, the car just broke. So now my bonus
Yep.
goes to that. Or,
Yep.
all right, well, mom is going to give me some money for Christmas, and then mom and I fall into a fight. So that doesn't come
Hmm.
through. And people just kind of don't see it snowballing.
They don't. What happens is, and I'll just think back to when I was, we were about the same age, I think,
Hmm.
close to. When we went to college, you went to the dining hall, and there were 4 or 5 people lined up with T-shirts and clipboards. You know,
Absolutely.
I don't think they're as bad anymore, but now they used to come up there. Here, sign here. Give us all your information. We'll give you a T-shirt. 4 or 5 weeks later, a credit card comes in the mail, and I know, this was the beginning of internet shopping. Um, and you could, cool stuff got delivered to your dorm room and you didn't have to think about it for several weeks. Um,
Yeah.
and that's what a lot of people start with. But what I tend to find is that people have this snowball, but it's usually external forces that cause the collapse. So you start to snowball, you start to build the credit card bills, but you're managing. And then, like you mentioned earlier, someone gets sick, you lose your job, something happens that's external to you that now causes that structure to fail, that debt structuring to fail. And I've had clients come in and they say to me, well, can I file bankruptcy on everything but no, my city card? I've been a member for 30 years. They've always been very good to me. And people have this, they personify the credit card companies, and they forget that they are business entities, and they're not your friend. They're businesses. They want to get paid. The executives would like their bonuses at the end of the year. So they don't really. It's not like a personal banker that holds your loan. It's a large corporate entity that has policies and not too much to do for you.
Yeah. Well, that's a scary thing for a lot of people because, I think a lot of people think of bankruptcy as kind of like, I'm basically putting my financial life on hold for a decade. And the way that you've described it, it's nowhere near as bad as
No,
I try to lead people to believe. Not that I want to steer people away from you, but whenever somebody comes in and says, "Oh my God, I owe $20,000, I should file for bankruptcy," I say, "You owe 20, but you make 80. Let's come up with a plan. Let's not, you
that's a
know."
good idea. If there's a way to do it without, okay, if there is a way to get out of it without doing bankruptcy, should be a, a last resort. If nothing else works, if the client that you're talking about has sufficient liquid assets or liquid funds every month to be able to do something, then by all means. But if it's too much, it's too much. I mean,
Right.
I've filed cases for people who make 80,000 with 20,000 in debt, but that $80,000 is taken up on childcare, mortgage payments, and all that other stuff. 80 grand does not go very far anymore.
Especially not in the state of New
No,
Jersey.
not in New Jersey. Once you start adding property taxes on there, you're done.
Yeah, right. In the state of New Jersey, you're one step above poverty when you hit the $80,000 mark. Uh,
Exactly.
but my friend
Especially with two
Julianne,
kids in school.
oh, I know, right? Luckily, I don't have that problem. As
Mm-hmm.
much as we don't like to refer to the kids as problems, we they are definitely an economic expense. Um,
But they're cute,
so
so we let them stay. Yes.
yeah, that's true. So my friend Judy Ann notes that sometimes there used to be big bonuses, and then suddenly the company
Mm-hmm.
stops paying a bonus, and now they're in major
Yep.
crisis because they made purchases based on bonuses not yet received.
Exactly.
Definitely true with executive comp. I know a lot of people. There was a very poignant article that came out. God, I think it was in the New Yorker. It's probably maybe 3 or 4 years ago now, but it talked about this idea of the wealthy welfare recipients,
Yeah.
and welfare recipients have a whole series of loaded terms and political catchphrases. So I don't want to go down that road for anyone watching. But you think of kind of the black welfare queen, but this woman was a white middle class woman. She had a six-figure job. Her husband had a six-figure job. they decided that she would stay home because she gave birth to twins, one of whom had some congenital problems. So she was not working, and then he lost his job. And
Hmm.
in a relatively short period of time, they lost their savings, and dwindling, trying to do what we could, and baby continued to have more problems, and the family is kind of robbing Peter to pay Paul and do what they can, trying to avoid the stigma of bankruptcy. And
Hmm.
then she goes out and she's driving her Lexus, and people are judging her, and she's going to the line to get food care and WIC and things like that. And people are saying, "How are you driving up in a Lexus and then taking advantage of the public dole?" And the answer is, well, this is a youth, this is a car that's, has no car lease, no car loan. I could
Yeah.
I could sell it and go out and get a jalopy, or I could keep my otherwise dependable piece of transportation. So, there are a lot of complex issues around finance, and I think we put a lot of judgment
Hmm.
around people regarding money. But
Yes.
because of that issue, I'm sure you see a lot of people that kind of slither into your office, kind of like in the dead of night. They want to hide themselves. They feel bad about their situation. But the
Hmm.
fact that you're telling us that there actually is a way forward, and that they don't necessarily have to give up all ability to do anything in their economic life over the
No.
next 4 or 5 years
Yeah.
is really, really hopeful.
Yeah. Bankruptcy is designed. One of the things that a lot of the judges in their cases quote, usually when they're about to bring the hammer down on someone who did something wrong, but what they always say is bankruptcy is intended to give the honest but unfortunate debtor a fresh start. That's usually what they say when they're about to point out that someone has not been honest, and that's when bad things happen.
Yeah.
But it really is designed. We always talk, and one of the, bankruptcy advertising, a lot of lawyers say fresh start, and that really is what we're about. We want to tell people that when you come into our offices or inquire, it's not about an end to your financial life. It's about putting whatever went wrong behind you, clearing out the detritus of all of that, and allowing you to move forward, taking what you have and bringing yourself to a new financial reality. Usually, a lot of times it's a better one. You have, I've had clients where they've got to get rid of the house that's too expensive, so we let them move on from the house. You get a smaller place that you can afford, and you restructure, and then you rebuild. Maybe buy a smaller house in a couple of years. Be able to save, be able to send your kids to school. These are all things that can become possible when you clear out what you've done before and the mistakes of the past. It really is a clearinghouse. It lets you wipe the slate clean. With the reorganizational cases, maybe you had some trouble paying your mortgage for a while because of a job loss or something. It's not the end of it all. It's not, it's not an inexorable slide down the road to a foreclosure and a sheriff's sale. I can, until the judge slams the gavel and the sheriff slams the gavel and says sold, that foreclosure can be stopped and in theory fixed.
Hmm.
You don't have to, a repo on a vehicle until they sell it at auction can be undone. All these things can be done and fixed. You don't have to go to jail because you couldn't pay your child support and you owe a lot of money. We can fix this and help you get, clear that out so that you can, do what's right by your children and still survive.
Yeah,
Because
absolutely.
maybe the guy who's not paying his child support because he's paying all his other debts that he has could pay his child support if we cleared out all the rest of the junk.
Yeah, and that's a good way of looking at it. A lot of things in the Internal Revenue Code are the product of political
Mhm.
debate and discourse, but at some point we premised our code on the values that our society holds dear. And obviously,
Mhm.
I think most of us would say we'd rather have you supporting your child than
Yes.
supporting your credit card company, because if
Yep.
you don't support your child, the government's going to support your child, whether because
One way or
obviously
the
the
other.
child
Yeah.
has entitled to or not. So but kind of turning to this issue of assets, we talked earlier about the idea that people could actually buy a house in bankruptcy or after bankruptcy. But what
Correct.
about people that are already homeowners? I know that some people have the fear that I'm going to file for bankruptcy and then they're going to take my house. So
Okay.
talk to us about the risk of that.
So, so everything in bankruptcy is about asset and equity. Okay, equity and debt. So when you own your house, you only have a certain amount of equity in it, depending on whatever your mortgage is. So if you have a house that's worth $300,000 and a $200,000 mortgage, you have about $100,000 of equity. Now, this is going to depend a lot on your state law, but there's a certain amount of equity that you can protect from the trustee and from your creditors in Chapter 7. So we're going to have to divide between reorganizational and not. Chapter 7, it's liquidation. Whatever's not exempted can be sold and liquidated by the trustee. So if you think about my favorite analogy is comparing it to a pie. Everything you own is a pie. And the code gives me slices that I can take out depending on what things are of the equity in that pie. My goal is to present the trustee with an empty plate and say, tough luck, nothing for the creditors. Take your $60 from the filing fee and let my client leave now. That's what we look to do. You have, I think the latest number is about 23,000, somewhere in that range of equity that you can protect in Chapter 7. If you have too much equity, you can do Chapter 13 if you have enough cash to do it, and you can, rather than hand the house over to the Chapter 7 trustee for sale, you can pay the cash equivalent of that equity to your creditors in Chapter 13 as part of reorganization. So you've got someone with $50,000 in unprotected equity. Well, first thing you do is take 10% off for cost of sale. Make sure that you estimate it properly. And then you see, well, what's left over? So $30,000, $40,000 of unprotected equity. That adds up to about a $600 to $700 monthly trustee payment to pay your creditors. But when you would otherwise have been spending $1,250 a month paying your credit card bills, that's a net savings.
Wow.
And you also save a lot on the interest for those credit cards. Because remember, you're paying whatever you're paying, 10, 12, 13% compounded interest. In a reorganizational case, you pay 10% flat. So you spend, over the life of your case, you pay $50,000 to your creditor. Through your plan payments, you end up paying $5,000 to the Chapter 13 trustee as an administrative fee. So you actually save quite a bit of money on what would be interest on that general unsecured debt.
Wow. Okay, so that gives you a lot of options to work with in terms of how somebody would ultimately consider what's going to happen. But you referenced the phrase "too much equity," and what does that mean? Is that a number? Is that a percentage value?
That is exactly. It is a number. So you look at how much equity there is in the property at that moment, which is very simply the appraised value of the property minus your loan. I'm sorry, the appraised value. I usually take 10% of the appraised value off the top to account for theoretical sale costs minus the mortgage, and that gives you whatever it is. Then you subtract the exemptions that you're allowed to have, and that's going to depend on where you live. In New Jersey, we use the federal exemptions, which are set forth in the Bankruptcy Code and amended every year in the Federal Register. And that gives you a relative, it gives you 20-something thousand per person, 20, 22, 23 or so per person to protect of the home equity. In New York, if you use state exemptions in New York, depending on where you live, you get anywhere from $75,000 to $125,000 per person. But, and that the higher values are in the 5 boroughs. Then you get some nice big exemptions. But since housing prices there are insane, if you've got someone who's owned their house since the 1970s and they bought it when the city was, almost bankrupt, they bought the house cheap in the 70s, they could have a tremendous amount of equity in that property, even if they only make $40,000, $50,000, $60,000 a year, because they bought it dirt cheap and prices have skyrocketed that much. In New Jersey, we're not going to have as much you're not going to have as much equity, just in general.
Yeah. Absolutely.
So it's going to depend, but it is an absolute number. The hard it's if you have more than about $60,000 in equity in your home in New Jersey for a married couple, you may have some trouble doing a Chapter 7 case because that equity would be anything over the exemptions is up for grabs. And depending on who your trustee is, you might have problems.
Yeah, definitely. So we have yet another attorney on the line, Amy Sarah-Kors, who's nice enough to know.
Hi, Amy.
This is the dream team of Legal Eagles. I'm going to watch the entire live in the morning, and I should, of course, note to anyone watching this live that Amy is my best friend in life. So I think she's a little bit biased. I'm not going to say she's wrong. I will just say I think she's biased. So we are coming to the top of the hour, Scott. And so
Yeah.
for those that are watching now, I will remind you that sharing is caring. Please do share the live so people in your network can learn about bankruptcy law and how that could impact the families that are within the purview of us here
Yeah.
in New York and New Jersey. And I would also note for those that are just tuning in that you're watching Moving Families Forward with Williams Law Group. I am Allison Williams, the owner and founder of Williams Law Group. And I have our wonderful guest tonight, Scott Goldstein, who is the innovator and founder of the Law Office of Scott Goldstein, where he helps people with a variety of issues, including bankruptcy. So, Scott, we only have a couple more questions that I want to cover
Okay.
with you.
And
One
I'll
of
try to
them
keep
is
my answer short.
well, we could always run over if we needed to because we're getting a lot
Okay.
out of this tonight. So you're not going to get cut off, I promise.
Okay.
But the question of about protecting creditors, you mentioned alimony recipients earlier.
Right.
But can bankruptcy actually protect them as creditors coming in and trying to save off their claims?
So it's going to depend on what the situation is of the debtor. So some stuff carries through automatically. If you have alimony and child support or equitable distribution claims in a Chapter 7, those ride through without any sort of interference from the court. That's just automatic. By contrast, if you think someone's committed fraud, you actually need to bring an action in the bankruptcy court called an adversary proceeding and get a determination that the debt was incurred by reason of that fraud or misrepresentation, and then that will survive through. So there are protections for creditors. A creditor can also appear at the meeting of creditors or any other proceeding in a bankruptcy court as an interested party and can voice their objections. I have had creditors show up. We will not very often, but often enough, see angry exes at creditor meetings who will tell the trustee about assets that perhaps their less than honest former partner has done, and tip them off. But there are significant protections. There's more protections in the business cases generally. I mean, bankruptcy is really heavily geared towards protecting the debtors from their creditors' actions, but there is enough in there to protect the claims if it's something that can be accepted from the discharge. There is no automatic stay for new child support garnishments. So, if you owe your child support or it's awarded against you, that can be collected. If there's a wage, they can continue to execute on that. Those sorts of things don't go away. So there's definitely protections for families, and child support and alimony recipients. Equitable distribution depends on what they're doing.
Yeah.
But and then the thing is that people who do have these claims, the one thing I cannot stress strongly enough, and this goes for debtors too, do not do it yourself. Bankruptcy is not, it looks simple because we have all these wonderful forms that the federal government and the local district courts put out. It is deceptively simple, and you can get yourself in significant trouble because if you file things wrong, you don't get what you want. If you're a debtor and you do it yourself, you could end up losing things that you want to protect. If you're a creditor and you file things wrong, you're dollars to donuts, you're not going to get your claim properly processed, and you're not going to share in the estate. You're not going to share in the payouts if there are any.
Yes, very, very important that people should be consulting a professional. Certainly, we recommend that Scott would be a great resource for anybody that has questions about what to do as a debtor or a creditor when they are aware of the possibility of or been made aware of a former debtor coming in and filing bankruptcy.
There's a lot of penalties if you do try to collect from a debtor who's in a bankruptcy. Even if you don't know, if you push it, you're going to end up in front of a very irritated bankruptcy judge. More importantly, there are very, very tight deadlines. I'll share a quick story with you, Allison, I had a client who had a divorce attorney. We filed a case and we were going to clear his claim out. He showed up at the creditor meeting very angry with us and said he was going to oppose the bankruptcy, going to oppose the discharge. The deadline, we had a lot of arguments and a lot of motions, but the deadline to file his objections came and went, and I did not receive the complaint that he would have needed to file. So I called him up and I asked him where it was, and he said, "Oh, I'm gonna file it." I said, "You can't. You're too late." Now in state court, if I remember correctly, and I don't do a lot of state court, you can kind of ask forgiveness and extend the deadlines after the fact sometimes. not in bankruptcy court. You have to file your application to extend your deadline before the deadline elapses. I would have killed to be a fly on the wall in that partner's meeting when he had to tell his partners that $100,000 had just evaporated.
Oh my God.
Yeah. Deadlines are important in bankruptcy. If you blow your deadline, you're done, even if you didn't know about it.
Yeah, and people need to hear that. Really, really need to hear that, because in family court in particular, we oftentimes, we get leniency. We can extend things. We can, if somebody doesn't give us the information we need as lawyers, we can go to the court. We can ask our adversary to consent. But the federal law is what the federal law is. Your deadline is dead. So if
Yes.
you don't hit your
Get
deadline,
extension, get it before it runs, because if you don't, that's it.
absolutely. Absolutely. Critically important information, and great information that we've gotten tonight from our guest, Scott Goldstein, who is the owner and founder of the law office of Scott Goldstein. Scott, I want to thank you so much for being on the show tonight. You've just
Thank
given
you
us a
so much,
wealth
Allison.
of information about bankruptcy, and I know that a lot of the people who are watching could greatly benefit from having someone like you on their side. So, for those of you that are even contemplating it, you might not necessarily want to out yourself. I am going to drop Scott's website link into
Thank
our
you.
comments, so you can always reach out to him and schedule a consultation with his office. Do know that he is available as a resource, and if you have any family law issue or concern and you need help, Williams Law Group is here, located in Short Hills. We service all of the state of New Jersey for our child abuse and neglect matters, but for matrimonial, family, custody, and related matters, we are in North Jersey. So we're here to help. We hope that this provided value for you tonight, and we want to thank you all for watching. Again, if you're catching this on the replay, please do share it with your friends in your network. And outside of that, we ask that you have a wonderful week. Bye bye.
Thanks, Allison.